Hello, my name is John Paul Boyd, and I am a family law mediator, arbitrator, and parenting coordinator working here in Alberta. I'm happy to provide this video for Alberta Health Services Community Education Service. I've worked with CES in the past, but normally it's about things like parental alienation or how to protect children from conflict between their parents. But today, I'm going to be talking about the coronavirus and the effect the pandemic has had on family law disputes. And so in this presentation, I'm going to talk a little bit about what's going on in the courts because they've been shut down since about the middle of March. And then I'll be talking about some of the case law we've had from across Canada to give you a bit of a flavor for how the courts are dealing with family law problems during this time of crisis. So, in general, the kind of problems that we're seeing are about contact between parents and children. So we have one category of problem, which is parents who are trying to suspend the other parent's contact with the children because they're worried about the children getting infected. And then we have the parents who are trying to enforce a right to see their children because the other parent has withheld their contact. We're seeing a few problems involving support. And as you know, in Alberta, not only have we been hit by all the job losses that you've seen in the other provinces, but things have been worse here because of the spat between the Saudis and the Russians that began sometime in January that has had a calamitous impact on the price of oil. And so in addition to all the other jobs we've lost jobs from the oil sector, things like layoffs and furloughs, reduced hours, or employers who are just simply reducing the amount they're paying their staff. And as a result of that, all sorts of people are having trouble keeping pace with their obligations to pay child support and spousal support. And then another area of problem we're seeing has to do with real property. This is really the least common problem, but typical issues you can imagine might be about if you have an agreement to sell the family home, well, now you've got a realtor who has to come in through the house, and then there's all the people that are going to come traipsing through on an open houses days, which expose the children to the likelihood of contracting the virus from somebody. So the courts. There are two levels of trial court in Alberta, the Provincial Court and the Alberta Court of Queen's Bench. And both courts shut down to all in-person hearings sometime around the middle of March. They were supposed to be closed until early May, but that was extended to the end of May. And now what I'm hearing is that they're going to stay closed for in-person hearings until maybe the middle of July. We're just going to have to wait and see. And so what has happened is that all the matters that were scheduled to be heard in court were administratively adjourned. They're just canceled. They'll be rebooked by the court at some point in the future, but when, we just don't know. The courts are still open, but they're only open to things that qualify as urgent. And so what that means is that if you have an urgent problem, first, you have to go to court to get permission to have your application heard because it's urgent. So there are some rules about what's qualifying as urgent and what's not. So in general, urgent applications are applications involving a risk of harm to a child or to a parent, a risk that a child will be removed from the jurisdiction or wrongfully retained, or where there is a risk of family violence and imminent harm. And so that's roughly the same rule, the same test for urgency that you see in the Court of Queen's Bench and you see in the trial court. And in both courts, there are specific protocols in place for the process that you have to follow to ask the court for permission to have your application heard before it's urgent. Unfortunately, in Alberta, each court kind of behaves like its own separate kind of thing. So the way the court works in Calgary is different than the way it works in Edmonton, and it's different than the way it works in Lethbridge. And so what you're going to have to do is you're going to have to visit the court's websites in order to find out what's going on with a court near you. Do you submit an application by email? Do you fill out a form online? Because both of those are potential options. So if you have a critical problem that you need to bring to the attention of the court, you need to go to the court's website and find out what's happening, not just in any court, but in the court that's nearest to you or in the court where your application, if you've got something going on, is already occurring. Now, Because the courts have shut down, it doesn't mean that people are no longer having urgent problems. The good news is that there are still ways that you can deal with those situations. The most common options that are available to you are mediation and arbitration. And the really cool thing about this is that you can arbitrate or mediate whether you're in the same room or not. And we've got professionals from all across Alberta who are offering these services remotely. So what you have is you have an arbitrator or mediator that you see on your video screen, just like you're seeing me, and they're contacting you through a video conferencing service like FaceTime, Skype, or Zoom. And along with you in the same kind of virtual room are your lawyer if you've got one, the other side to your case, and their lawyer if they've got one. And so you can have your applications dealt with even if they don't rise to that level of urgency. It's just a matter of reaching out and contacting somebody who's a family law mediator or a family law arbitrator to set up a mediation or an arbitration. And none of you need to be in the room at the same time. So this will work. And the other good news about mediation and arbitration is that, believe it or not, you can get in to see a mediator or an arbitrator more quickly than you could get in to see the judge, even when court was open. Because all you have to organize to see a mediator or an arbitrator is your calendar, your ex's calendar, the calendars of your lawyers, and the calendar of the arbitrator or mediator. And normally we are far more flexible than the court is in terms of available time. And so let's talk about some of the cases that we're seeing. The first thing is that a lot of judges are begging and pleading for parents to demonstrate common sense, to talk to each other before they come to court with an urgent problem. So if you have something that's come up, call the other parent, send them an email, try to resolve the problem by talking to each other before you go to court. Because you've got to remember that the court is profoundly understaffed, right? People are working from home, they're not in the office, and there isn't the same abundance of judicial resources that are going to be available to deal with your problem. So don't come to court unless you absolutely have to, and first try to talk to the other parent. The other trend in the case law is that the court's primary interest is in the best interests of children. That is the court's mandate under the Alberta Family Law Act, and it's the court's mandate under the Federal Divorce Act. All decisions about kids are supposed to be made taking into account only their best interests. And so what that means in family law problems is that the court is taking a zero tolerance approach to anybody who is not doing everything they can to protect their children from the coronavirus. And that means the court is expecting that every parent is going to be complying rigorously with the healthcare protocols that have been released by the province, released by the cities, and released by the federal government. The other issue is that when you have to go to court and ask for leave to have your application heard, that decision is made on what they call a summary basis, which means that it's kind of a rough and ready sort of justice, that they're not going to get into the full nuts and bolts of the case and they're not going to read 200 pages worth of affidavits. They're making a quick decision and you're just going to have to live with it. And the other part of it is that when there are rules that regulate what comes into the court, you can expect the court to follow those rules to the letter. So let's talk about a few cases. The first case I want to mention is the leading case in all of Canada, and it's a case out of Ontario called Ribeiro and Wright. And what was going on in that case is mom was asking the court to suspend dad's time with the kids on the basis that dad wasn't observing the healthcare protocols and social distancing. And among the many things the court said in that particular case is it said that the health and well-being of children is the court's top priority. It said that the healthcare protocols must be observed by everybody in a parent's household. So it's not just the parent and the child, it's new partners, it's housemates, it's anybody else you happen to live with, and that the court has zero tolerance for any parent who is exposing the children to risk. Most importantly, perhaps, the court said that there is a presumption that any parenting schedules that are already there in an agreement, an arbitrator's award, or a court order should continue to be followed. However, the court went on and it talked about the idea that there are some kinds of parents who are going to have no choice but to maybe forego their time with the kids. And so there are three categories of parent that might be subject to this kind of withholding. It's a parent who is under a personal restriction because, for example, they've recently left the country, they're back, and now they have to quarantine for 14 days because they've been sick for the virus or they've been in contact with somebody that's been sick from the virus. Another category of parent might be parents who have risk factors because of the nature of their employment. Like if they're a frontline medical worker or if they work at a grocery store, they're exposed to people all the time and they may have no choice but to suspend their time with their kids. And then finally, and the worst category, are parents who have just made the choice that they're not going to comply with healthcare protocols. And so parents who fail to observe the protocols that are published by the governments may see their parenting time withheld. That is not good. Then there was another case, and it was a case named Thomas and Wolliber, also out of Ontario. And what happened in that case is that the father had withdrawn $750,000 from the family's line of credit, right? And in the superior courts, like the Ontario Superior Court of Justice, or in Alberta, the Court of Queen's Bench, the court will deal with matters that have an urgent financial dimension to them. And in this case, the amount of money that the father had withdrawn was more than 5 times the mom's annual income. And it was an amount grossly bigger than the equity available to the family. And so if the court didn't step in and do something right then and there, the family could have been looking at financial ruin if they had to wait to do something about this until the COVID-19 crisis had passed. Now, here's what the court had to say about urgent applications. The court said, the concern has to be immediate. It's got to be something that just can't wait. The court said that the concern has to be serious, in that the concern affects in a serious way the health or safety or economic well-being of a child or a parent. And the concern has to be definite and material rather than speculative. In other words, it has to be not theoretical but tangible, right? So it has to be a real problem, not just something you're worried about. And the details of the problem have to be clearly spelled out in the application materials. Okay, so that was one important case. And then there was a case called Lee and Norris, another Ontario case. And what was going on there was the father was applying to enforce his parenting time with the children because mom had decided that she was going to withhold that time. And in that case, and of course, mom's concerns were about whether father was going to comply with the healthcare protocols. And so what the judge in that case decided was that, the two parents, should have been able to work this out. And that parents have an obligation to responsibly adhere to orders, awards, and agreements about parenting arrangements, and that if they'd only been responsibly adhering to that, the whole application could have been avoided. And of course, the question is, well, what does responsible adherence mean? And the court says this: what do I mean by responsible adherence to the existing court order? I mean being practical and having some basic common sense. Physical distancing measures must be respected. The parties must do whatever they can do to ensure that neither of them nor the child contracts COVID-19. Every precautionary measure recommended by governments and health authorities must be taken by both parties and, with their help, by the child. Neither party shall do anything that will expose him or herself or the child to an increased risk of contracting the virus. Those are pretty strong words for the court, and that's a takeaway lesson, right? Don't go to court unless you absolutely have to. And before you do that, try your best to be flexible and work to each other so that you can observe all of the healthcare protocols while respecting each parent's time with the children, and more importantly, the children's right to time with the parent. And another case out of Ontario was a case called Tessier and Rick. And in this case, the father was trying to force mom to comply with the parenting order because she had been withholding the child on the ground that the parent wasn't observing the protocols. Mum, on the other hand, was applying to suspend Dad's time. And so the court had to consider the Dad's application, whether it was urgent, and Mum's application, and whether it was urgent. So the court decided that Mum's application was urgent because she was making an allegation that the child was at risk. And so in this case, the court said that the burden lies on the person making the application to show specific examples of behavior or planned behavior that is contrary to the health protocols and therefore exposing the children to risk. The court also said that short periods of withholding a child from a parent may not rise to the level of urgency required to get in front of a judge. And that certainly an application like the dad was making for makeup time didn't really qualify as urgent. So here's what the court had to say. I find that an urgent motion is warranted, but only on the narrow issue of whether the father's regular access should be varied temporarily due to the mother's allegations that the father is exposing the child to significant risk as a result of not complying with the COVID-19 safety measures. While the withholding of access, particularly over a short period such as 1, 2, or 3 weeks, would not usually meet the threshold of urgency, in this instance it appears that the mother intends to deny the father access for an extended period of time. Also, the child's young age at 3.5 years is a factor that also favors a finding of urgency. So the first part about contact and short periods of withholding is kind of obvious. What's really important is the judge's comments about the age of the child. And so you remember from your own kids that it's not until they're maybe 4 or 5 that they start talking about the amount of time that has to elapse until Rosh Hashanah or Christmas in terms of number of days, or number of sleeps, that is, right? And that's because children don't have the cognitive capacity to understand what long periods of time mean, right? So children, can't think of the passage of time in terms of 2 weeks or 2 months, but they can think about it in number of sleeps, right? Because that's something concrete and tangible that they do each and every day. So kids talk about, when's Halloween coming? It's 2 more sleeps, right? But a period of time like 2 weeks is almost an unfathomably long period of time for a child. It's immeasurably long. And so for a child to not see a parent for that amount of time can be really bad for them. And now let's talk about another case called Scoos and Scoos, also out of Ontario. In that case, the father had been staying in a residential addiction treatment facility. He'd finished his time at the facility, had moved out, and was living with a friend. And at the time of his application to enforce an agreement giving him time with the kids, he was planning on leaving his friend and moving in with his parents. The mum had said, I don't want you seeing the kids. You can see them by video conference, but I don't want you seeing them in person, because she was concerned about who it is that the father had been in contact with, and of course wanting to protect the kids from exposure to the virus. The judge says, the mother is essentially wishing to resile from the agreement due to intervening world events, which is a nice way of saying that mom was deciding that she wasn't going to uphold her end of the contract because of the virus. And what was interesting about the case to me is that the judge found that the urgency of hearing this application had to do with the children losing their contact with their father, and the importance to them of maintaining the frequency of that connection. The court said, it is vital for the children of separated families who have parenting times with caregivers to be provided with some certainty. The certainty which is contained in court orders should be respected. In this way, litigants can ensure that children's best interests are safeguarded during this troubled time. And here is my all-time favorite sentence from a judicial decision. The court cannot condone self-help remedies, which is what simply deciding not to obey an order amounts to. And the court says, without citizens obeying existing court orders, the whole justice system would be turned over on its head, which is a dramatic way of pointing out the truth. Then let's move on to a case out of British Columbia. This case is called SR and MG. And what was really interesting in this case is that you remember at the very beginning when we were talking about that case called Ribeiro and Wright out of Ontario, and it was talking about those three categories of people who might have to forego time with their kids. And one of the categories of people was people who have a job that exposes them to risk. Well, that was the case in SR and MG, where mom was a licensed practical nurse working at a hospital, and so of course was being exposed to people with the virus at a much higher rate than anybody else. So dad, of course, said, this is too risky, and I'm not going to return the kids to you. And this was another spring break case, so he'd had the kids from spring break and just kept them. And Dad quite generously said, I'm going to keep the kids, but don't worry, I'll bring them by your condo building so you can look down at them from your balcony and still see them, which is pretty crappy. But so the interesting thing, though, for the court is, well, how do you balance the children's interest in seeing their mother against the mom who has this sort of high risk kind of job? And so the judge spent a lot of time talking about the mum and her occupation and what she was doing to take care. So first of all, she was taking every precaution, said the judge, that was recommended to the nurses at the hospital and then some. And her daily routine, when she's leaving work, she would leave her shoes and her clothes there, get changed into something new. She would go home, and when she got home, she would take off those clothes, have a shower, and then return to wipe down everything she'd touched since getting home with bleach. And what the judge said, thinking about, what are the factors I should consider, said that there are a constellation of factors to consider when deciding what is in the children's best interests about seeing a parent during the coronavirus. First, the judge said that one of the factors is whether a child is at an elevated risk of suffering the more severe consequences of the coronavirus. And so a child who would be typically at an elevated risk would be a child with a compromised immune system, or a child with a pulmonary disorder like asthma, or some other problem like that. Second point, whether a party or someone in the household of a party is at elevated risk of suffering the more severe consequences. So what that's usually talking about are the elderly, because we know from what has been happening over the past couple of months that older people, our elders, are much more vulnerable to the coronavirus and the more severe complications. But people who are at elevated risk also include adults with compromised immune systems and people with lung problems. The third point was each party's exposure to the risk of contracting the virus, and obviously for the mum in this case that was a higher level of risk because she's a nurse working in a hospital. Fourth point to consider was the steps taken by each party to mitigate their risk of exposure to the virus. The fifth point were all of the factors that are set out in British Columbia's Family Law Act about the best interests of the child. Now, Alberta's Family Law Act has a similar list that appears at Section 18 of the Alberta Family Law Act, and it's quite long. It includes things like the history of the child's care, the child's cultural and religious connections, each parent's willingness to facilitate the children's relationship with the other parent, and a few other things. The last point that the judge points to is society's need for these frontline workers and the resources in the community, which is a really interesting point because what the judge is talking about is the risk of exposure to the child to a parent and the possible loss of that parent from the front lines. And so ultimately, what the judge decides is that the child is going to stay with the father for a few more days to complete a complete 14-day period. And we've heard about the 14-day period in terms of the amount of time that has to elapse from exposure to the virus until the date that you begin to demonstrate symptoms. So the child would stay there for another 4 days and then go be with the mom for 7 days. And then the parenting time schedule that pre-existed the coronavirus would return. Now, there were some conditions. Mom was told that she wasn't allowed to work during her parenting time. Each of the parents are required to notify the other if they get flagged as being at a higher risk for the virus. And ultimately, what the judge decided was that, yes, there's a risk, but the mom had mitigated that risk by abiding for all the precautions that were required of nurses at the hospital and then doing more. And the next case I want to talk about is Divetta and Divetta, a case out of Ontario. This case involved Dad who was asking the court for an urgent meeting in order to start seeing his children again. And this case sort of goes back to that Ribeiro and Wright case because it's talking about the importance of parents trying to communicate with each other and work things out before going to the court. But the most important part of this case is this sentence from the decision. I expect, says the judge, that the parties in this matter will come to the meeting with the judge with realistic solutions to their parenting issues. And here's the critical sentence. An unreasonable failure to support a child's relationship with the other parent is a failure of parenting. And that's a really important statement because a lot of the law about parenting time and things like that has to do with the obligation of each parent to help the kids look forward to their time with the other parent and to nurture the children's relationship with the other parent. And that's really what the judge in this case was getting to. But in the context of COVID-19, that general idea was recast in terms of the importance of making sure that you as a parent make sure the kids are continuing to see the other parent. And then let's talk about another important case, and this one's back to British Columbia. And this case, which is called VCS and TS, was another one of those spring break cases. And what had happened is that the kids lived with Dad in Prince George, which is, in the northern interior part of the province. And they'd gone down to visit their mum who lived in Pitt Meadows, which is a suburb about an hour and 15 minutes outside of Vancouver downtown. And they'd been down to visit Mum for spring break, and then of course the coronavirus comes along, and Mum says, well, you can't go back to see your dad. And so Dad was asking the court for an order that Mum return the children to him because, of course, he had their primary residence. Mum was withholding the kids because she was worried about their safety on their trip from Pitt Meadows all the way up to Prince George. Dad had proposed a solution. Tell you what, we'll meet at the midpoint. I'll drive in my car with nobody else there. You drive in your car with nobody else there. But that was still not enough for Mum. She said that the trip was still too dangerous. And so the issues came up, and these issues have come up in a lot of different cases about how do you make these long distance trips with kids? What is it safe, and what does safety mean? So the mum's first complaint was about, well, how are the kids going to eat? Because if you get fast food, they're going to be in contact with the packaging. They're going to be in contact with the people who work at the restaurant, and they'll catch the coronavirus that way. Well, says the judge, this. I find the issue of food consumption is readily dealt with by the mother packing meals for the children to eat on the road, which would eliminate the need for them to handle packaging associated with takeout food. I question whether such precaution is even necessary, given that our public health authorities have deemed it safe for Canadians to attend drive-thrus and consume takeout food in the course of the pandemic. I do not find the children's need to eat on the journey a compelling basis to justify the temporary change of residence that the mum was seeking. But then, of course, there's the issue about where do the kids go to the bathroom. And of course, the side of the road wasn't a good enough answer. And so the judge dwells on this for a fair amount of time, saying, with respect to the children's need to use washrooms, there are numerous rest stops and gas stations on the highway between the Lower Mainland and Prince George, which, by the way, is about an 8-hour drive away. The public health authorities have not considered such amenities to be of sufficient risk of viral transmission to warrant their closure. Indeed, numerous truckers and delivery persons continue to use these facilities during the course of this pandemic to keep the vital supply chains open. And that wasn't it. The decision went on, talking about, and you can put down strips of toilet paper on the toilet seats and all that. Ultimately, the judge decided to require the mum to return the kids to the father and included something called a peace officer enforcement clause, which is a direction to the police to intervene to enforce the order in the event that mum decided that she wasn't going to do that. Next, and finally, let me talk about another case called SAS and LMS. And this is a case from Alberta, and it's one of only 2 Alberta cases that really talk about COVID-19 in any detail. And as you probably guess, the judge in this case borrows heavily from Ribeiro and Wright, like it's the most important case in Canada for a good reason. So, in this case, Dad was applying for an order that mum be found in contempt of court for breaching an order by withholding the children from him and refusing to allow him to have the time with the children that the order provided. Now, and this harks back to that BC case about the nurse. Mum was concerned about the fragility of her own mother, who was elderly and more vulnerable to the COVID-19 virus than other people might be. And so Mum's concern here wasn't so much about protecting the child from the coronavirus, it was that if the child gets exposed and comes back to live with her, what's the risk of the child infecting the mother? So that was interesting. And Mum's accusing Dad of all sorts of things involving not complying with the public health protocols, having people over to visit, not wearing gloves when going shopping, not sanitizing his car after shopping, taking the kids horseback riding. And I'm not really sure which of those, except for having people over to visit, was a breach of the health protocols, but that's what she was talking about. And so the general principles you can draw from this case, the judge says, and again, this is harking back to a lot of the case law that we've already talked about, parents are expected to try to address their coronavirus concerns and resolve them before going back to court. If there is a risk differential between houses, and this is an important point, and the idea here is that one house is less risky in the sense that the children are less likely to be exposed as a result of the behavior or the occupation of the parents compared to the other house where there's a greater risk. So if there is a risk differential, the children should stay in the less risky home, and parents should maximize the children's contact with the other parent using virtual means like Skype and FaceTime and Zoom. And then the judge also says that the burden to change the order, or the burden when somebody is applying to change an order, lies on the person trying to change the order, right? So, and again, we've seen that in the other cases, and it's talking about that obligation to prove that there's a tangible risk to the children and things like that. However, if a parent simply cannot wait to get into court to change the order, the court here actually appears to say that it might be okay to simply breach the order or breach the agreement or the arbitral award, as long as the person who's doing the breaching tries to get into court as soon as they possibly can. The judge says applications based on speculation, mistrust, or fear without credible evidence of material non-compliance posing unacceptable risks to the children are unlikely to get permission to proceed as an emergency application. So remember that other case that was talking about, applications that are being made on fears rather than evidence of non-compliance, about fears that were theoretical rather than tangible. This is again getting back to that. And so my favorite quote from this case is this: unilateral action or self-help remedies, in other words, just deciding that you're not going to comply, but self-help remedies can never be countenanced. They may, in exceptional cases, be forgiven, and this is where we get into that exception to the idea that non-compliance with court orders is always a bad idea. And the judge has 3 circumstances where it might be okay to simply not comply with an order. One is when a parent is diagnosed with COVID-19 and insists on still exercising face-to-face access with the child. Well, offhand, that strikes me as foolish, and it probably seems foolish to you. If you have tested positive with COVID-19, surely to God, you're not going to try to continue seeing your kids and risk exposing them to the virus. Second category, where a parent is displaying symptoms of COVID-19 and continuing to see the kids or is not doing anything about it. And again, it's common sense, right? If you have the symptoms, surely you're not going to be taking any risk in exposing your children to it. And the third category is where a parent has or is about to do something involving the children that poses an immediate threat to their health or safety. So all things considered, this is a very unusual decision, because the court is saying there are in fact circumstances where a justifiable fear, and again, not theoretical but tangible, right, it exists that about the children's likelihood of getting exposed to the coronavirus. And so in those cases, maybe it's okay. So let's get back to the beginning. What we talked about is we talked about how starting around the middle of March, both the Alberta Provincial Court and the Alberta Court of Queen's Bench shut down, and they've cancelled all of their in-person hearings, case conferences, trials, and other intersections between the public and the courthouse. Currently, they're planning on resuming some operations as of May the 31st, but trials will still be cancelled and will not go ahead until sometime in the middle of July, if they go ahead at all. Now, even though the courts have been shut down, it has been possible to get into court if you can get a judge to agree that your application is urgent. And urgency is defined by the orders that the court has issued as issues involving a threat to the health or well-being of a family member resulting from family violence, issues involving the risk that a child will be removed from the jurisdiction or wrongfully retained, and issues having to do with child protection, as well as other issues as long as they rise to a level of urgency and a judge agrees that they should be heard. Now, some of the courts are beginning to slowly reopen and expand the number and the type of applications that they'll hear. But you'll still need to talk to the court to find out what's going on, and you probably still need to get permission to go before the judge. And remember that each court is run like an independent fiefdom, as if they're not all within the same province. So if you're in Edmonton, you need to go to the court's websites to find out what's going on with the courts in Edmonton. It'll be different in Calgary, it'll be different in Lethbridge, it'll be different in Red Deer, and so on throughout the entire province. So you'll have to look at that. Now, remember also that if something is really important but doesn't rise to that level of urgency where you can get in front of a judge, there are options. And those options include mediation and arbitration as probably your best alternatives to court. And the good news about mediation and arbitration is that you can probably get in to see a mediator or an arbitrator sooner than you would have been able to book a date in court when the courts were functioning as usual. And the other good news is that most people who provide mediation and arbitration services are prepared to do it online. So each of you, your lawyer, your ex, their lawyer, and the mediator or the arbitrator are in separate rooms, and all of this is being conducted over video using a video conferencing service like Zoom, which happens to be the service that I use. So that's what I have to say about what we're doing with COVID. My sincere hope is that we're beginning to veer towards the end of the restrictions, but not unnecessarily. I really do hope that everybody is safe and that the trend of the virus in Alberta continues to go down the way it has for the last couple of weeks. So please be good to yourselves, be good to your children, and be good to your ex. Listen to what the courts have said about the importance of trying to be sensible and exercising common sense and talking to your ex before doing something unilateral, like simply withholding time that the other parent is entitled to, or deciding that you have to go to court. There are options. So I wish everybody good luck, and be safe and be well, and thank you very much to Alberta Health Services, and in particular their Community Education Service. Thank you.